Hello friends, I am Advocate Vijay Kumar back again, the new topic for you. Today, let me discuss with you the repercussions of a check bounce. Check bounce, you might be already knowing that it is a criminal offence in India and it attracts a maximum punishment of 2 years in jail and or a fine of double the amount of the check. Could be jail or fine or both depending on the seriousness of the issue and how the judge views the act of check bounce. Before we get into this, let us understand what is a check. Who are the parties connected with a check? A check is a written instrument, an instruction to the bank by the account holder that on demand they should pay a specific sum of money to the person named therein on or after the date mentioned on the check. The amount is mentioned in words as well as in figures, and you sign the check. So it's an instruction to the bank. You are opening an account, so the bank gives you a checkbook in which everything else is printed. You have to just fill in the name, then you'll have to put the date, fill up the amount in words and figures, and sign it. That's it. The rest of the things are already worded, printed. Your account number is also printed by most of the banks, or they'll put a rubber stamp mentioning your account number, and you have to sign it. It's a very simple thing. Now we should know legally what are the terms used. The account holder is called drawer of the check, and the person in whose name the check is issued is called the payee of the check, one who gets paid. And the bank, which is supposed to do that, which is supposed to obey the instructions of the account holder and pay the amount, is called the drawee. So we've got three parties to check. One is the payee, the other is the drawer, and the drawee. The account holder, the bank, and the person who is named on the check. Now, the check can bounce for so many reasons, not just one, not just insufficiency of funds. There are so many reasons it can bounce. We'll see all of them, we'll see one by one. Maybe the date is not written properly. For example, if you put an impossible date like February 31, maybe a mistake, okay? But yet, it is an impossible date and therefore the bank will not pay the check. Because what is the bank supposed to do? It's supposed to obey your instructions. You are asking the bank to pay on 31st of February. Is it possible? Does any time February 31 come? No way. So the bank cannot pay. Okay. So the impossible date, the bank will not pay. The check will bounce. In case there is a difference in signature, how does the bank accept the instruction? It is based on your signature, which is supposed to be not copyable by somebody, not being forged by somebody else. Okay, so that is the authentication against which the bank affects your instructions. So in case the check signature on the check is different, then the bank will refuse to pay, the check will bounce. In case it's the name of a company, there has got to be a rubber seal. For example, if it is for ABC Limited, Private Limited, Managing Director, then that seal should be there because the account is held in the name of a company and on behalf of the company, the Managing Director is signing it. If that is not there, the bank can still bounce your check and therefore it will not get paid. If there are two signatories to a check in the name of a company, only one has signed, even then the bank will bounce the check. And in case the words and figures, suppose you write 1000 only and then in figures you write 100 or maybe 10,000, then they don't match. If the words and figures don't match, then the bank will bounce the check. It will not get paid. But legally, the bank has got a right to pay the amount mentioned in words because it is presumed by law that what you write at length is something which you consciously do, whereas when you write numbers, maybe there could be a mistake. But banks, as a matter of abundant precaution, they will not make a payment if there is a mismatch between the amount written in words and in figures. If there is any material alteration on the check, maybe the date, instead of, say, for example, the month has just crossed over to the following month, from November you come to December, but you put the date there as January. You remember that it is not January yet. So suppose, let us say you put it as 8/1/2018 by mistake. Now what you do is you try to squeeze in number 2 to make it 12th month. Try to squeeze it, and then the figure is not working out properly. You again rewrite on that, overwrite on that. Then there is called a material alteration in the check. The bank will bounce the check. So anything that is considered material alteration, name of the payee is overwritten, the amounts and figures you made a mistake in writing it, and therefore you cut the words and then you write on that without your signature on it. The words, the number and figures also you try to overwrite because it looks like 5 or 6 or 8 or 3. 3 and 8 sometimes get confused. People can get confused because the figure is not written properly. So in that case, you try to make it clear by overwriting on it, and it is not clear, then the bank will bounce. So material alteration is once again something that is not acceptable to the bank. If the check is presented after 90 days from the date of the check, then again it is called a stale check. The life of a check for getting payment is only 90 days, and if it is not presented within 90 days, then the bank can bounce the check, telling that the check has become stale. That's a banking jargon that is used, stale check. So bank will bounce the check also. And in case the person is deceased, the bank has come to know that the drawer of the check has died, passed away, then no further checks of the particular person will be passed and the check will bounce, will not get paid. And in case the person is given a stop payment, if the drawer of the check has given a stop payment for whatever reason, then also the check can bounce. There are so many other reasons. But here we are going to focus on what gets you punishment. There are several reasons for which a check can bounce, but there are only 2 reasons for which you can get punished. For issuing a stop payment instruction and for not maintaining adequate balance in your account. In case of unsound mind, in case the drawer of the check has become of unsound mind, or is declared insolvent, then also the bank will bounce the check. Okay, and in case the account is closed before being paid, even then the check will bounce. So there are so many reasons. So we will focus now, having known most of the reasons where normally there might be mistakes, which is not an offence as per law. We will now focus on issues which will attract the law against you in case you are issuing the check, in case you are the drawer of the check. So what is the proof that the check has been bounced? Naturally, you get back the check from the bank. There will be a check return memo, check return memo, RETURN, check return memo, in which lot of reasons will be pre-printed. I mean, whatever reasons I told you why the check will be bounced, all of them are pre-printed on the slip, and the bank will just stick whatever is applicable in the present case. Now we are going to discuss where there is insufficiency of funds or your stop payment of the check. These 2 cases, or you have closed the account before the check can be presented, then in the eyes of law, there is a suspicion that you wanted to deceive the payee by not paying the amount. You had no intention of making the payment. Therefore, it attracts the penal provisions of the law. Now, the proof of that is when the bank issues a check return memo, officially called that, and ticks either check stopped or insufficiency of funds or account closed, then you are going to have problem. So in case you are the person who has presented the check, let us take first, you are presenting a check. Somebody has issued a check to you, you are presenting the check, and the check comes back to you with the check return memo telling that insufficiency of funds or account closed or payment stopped by a drawer. Then what do you do with this? Then you'll have to follow the legal procedures. Now earlier days there used to be you will have to go to the particular bank branch and your check has got to be collected. Now, if you are selling some goods to somebody in Bombay and he gives you a check in Mumbai, check in Mumbai, he supply goods to Mumbai, he gives you a check drawn on a bank in Mumbai. You accept that check on the due date or immediately after the sale is done, you send it for collection through your bank. So let us say SBI Mumbai is the account holding branch and your bank is Canara Bank, say MG Road branch. Then you submit the check to Canara Bank MG Road, ask them to collect the proceeds from State Bank of India Mumbai branch. So what the Canara Bank will do, they will collect the check, they will send it across with a covering letter to SBI Mumbai. SBI Mumbai will check whether there is a balance in the account or not. If there is no balance, they'll again send back the check to you with the check return memorandum. This is for collection of checks outside the state. Now what happens inside the state? Within the clearing house jurisdiction. Clearing house means it is conducted by RBI, where all the banks within the specific area can exchange the checks coming to Reserve Bank of India. So in that case, it is faster. The check return will be faster, at the most the next day itself. You will know about it. In the case of outstation checks, maybe it will take 15-20 days depending on the distance from where you have presented the check and where it is gone for collection. So when the clearing house, you have to be very careful when the check is local, when you are presenting the check, because the check will get cleared the next day itself. If it is not, you are allowed to follow up with the bank, whether it has been paid or not. One thing is, today we have got core banking services. In core banking service, what happens? We have got multi-city checks. So multi-city check means specified cities you can issue the check. It can be encashed as if it is a local check. It's a convenience. And sometimes you can go to any branch of the bank and collect the payment. That is also possible. For example, you got a State Bank of India Chandra Layout branch. You can go to State Bank of India MG Road branch or any other branch, say JP Nagar. You can present the check there and collect it. This is also possible. Now let us say you have presented the check, the local clearing for example, check has bounced, the bank has returned the check to you with the remark insufficient funds. Now you have got a baby in your hands, you have to take care of it and see that the natural process, the legal process is initiated if you are really interested in getting your money back. Now wait a minute. There are certain situations wherein you cannot file a case. You cannot demand payment. But somebody has issued a check. How can this be? What if somebody has given you a gift? See, there's a birthday and your friend gives you a check for 1,000 rupees and then when you present it for payment, it is bounced. So can you go against it? No, obviously. In case you got a rich uncle or an auntie, it was your marriage and so they gave you a check for 1 lakh, it got bounced. No balance. So can you go and file a suit against them? No. The amount mentioned on the check must be a claim against the drawer of the check. He must owe you that money. It must be a debt, actionable debt. Actionable means the period of limitation of 3 years from the time he is due to you the money. You should have made the presentation of the check or he should have given you the check for you to collect the payment. So in case there is no actionable claim, there is no legally acceptable claim against the drawer of the check, then in that case, you cannot file a check bounce case. So first and foremost, somebody must owe you money, legally acceptable debt, only then you can go for a check bounce case. And gifts, presents are not acceptable in case it is proved to be so. What if somebody is trying to help you out? You ask somebody for money. They gave you, but the check bounced. Again, you cannot go for a suit. Because the basic tenet is, he must owe you the money. In this case, he doesn't owe you the money. So you cannot go against that. Now, what is a check? What is that makes it so acceptable to everybody? Today we see that banks are accepting checks instead of you going to the bank or giving a standing instruction. They prefer checks. the preference for checks is so pronounced that even if you have the capacity to pay, if your EMI is say 10,000 per month and you got the capacity to pay even 50,000 a month, yet the bank will ask you to give post-dated checks. Why is that? Because check bounce is considered a criminal offence in India. In which case the bank has a hold, they can threaten you that they'll take you to court and you will get scared that nobody wants to go to court or police station. Therefore, they can recover the amount. And many of the banks, private sector banks especially, do resort to a sort of thuggery or blackmail that even before they sanction you the loan, even before they release you the loan, they ask you, in case if the loan is for 36 months, 36 EMI checks plus a check for half the amount. Suppose you're taking a loan of 1 lakh, they'll ask you to give 36 EMI checks plus one check for 50,000 undated. They will also ask you to give a check for the full amount, 1 lakh, again undated. That is illegal. RBI does not recognize this kind of a repayment schedule. RBI does not instruct the bank to take this. It is their own innovation, their own what you call methods to recover the money in case of a default, so that the threat can become very real. Imagine that in case the check presented is for 1 lakh, whereas you have paid about 10 EMIs, then what happens? You will end up paying double the amount as fine if it is proved. Bank can always prove a liability. They have documents to show that they have given you a loan. That is the reason banks insist they want a check. And in many cases, banks have not released the loan or do not even consider the loan. If you say that I will not be able to give a check, I will make the payment directly to the bank. I will pay cash. They will not. Though technically we say that you have got the bank will give you a loan only if you have a repayment capacity. You have got a capacity to repay, then the bank is supposed to give you a loan. But no, if you are not giving a check, they will not, because they are afraid how they will recover from you if they don't have a check. So check is an instrument which comes in handy because the law says if it bounces, you are liable to go to jail for 2 years or pay a fine of double the amount of the check, or both. Could be either or both. Therefore, you will have to be very careful when receiving checks as well as when issuing checks. Now, what actually is a check? It is called a negotiable instrument and is covered by the Negotiable Instrument Act 1881. Of course, there have been a lot of amendments subsequently, depending on how the times are progressing. We only had one single branch accounts those days, then people had multiple branch accounts, then trade started expanding, so people started giving outstation checks to buy materials. Okay, now we have got core banking system, times are changing. So according to that, the laws also keep changing. So now you have got in your hand from the bank the original check that you presented for payment, as well as a check return memo in original, signed and sealed by the bank and dated. In case the bank issued a check memorandum today, return memorandum today, then it will be dated 8th December 2018. There will be a signature of the bank, and for whatever bank it is, they'll put a seal and sign and give it to you. Sometimes it is a computerized environment. It is possible that the check return memorandum may not be signed, but it is better for you if you're going to go for a legal recourse that you want it signed by the bank. There will be a stipulation, qualifying remark below that statement telling that this is a computer printout and therefore signature is not required. Sometimes court insists that it does not have the signature of the bank manager or does not have the seal. Okay, but date will always be there. So therefore, to be abundant precaution, you can go to the bank and tell, sir, I am going to go for a case, I need a signature on this, because court will insist on that. They might oblige you. So you have now got these two very important documents if you want to proceed further. What should you do? The law requires that within 15 days from the date of receipt of the bounced check, along with the check return memorandum issued by the bank, you are supposed to demand payment of the bounced check. The demand for payment of the bounced check should be in the form of a legal notice. Notice for demand of payment. And in that you have to mention that he owed you this money. basic characteristics of a demand notice, because the law says unless he owes you money, they will not qualify for filing a case against him. Therefore, you have to mention in that demand that you me this money, or even more. This repayment is only a part of it. This check represents only a part of the amount that you owe me. Okay, and then on such and such a date, at such and such a place, either my office or your office, you issued me this check, and I accepted in good faith, and I have presented the check well in time before the completion of 90 days, and the bank has given a return memorandum that there is no funds in your bank account, and therefore the bank has returned the check unpaid to me. So you are hereby called upon to pay the amount of the check within 15 days of the receipt of this letter, failing which I will initiate legal proceedings and criminal proceedings under Negotiable Instrument Act section 138. It's popularly called section 138 under the Negotiable Instruments Act 1881. And then the process starts. You send it by registered notice acknowledgement due. You can use either yourself send it or send it through an advocate, preferably through an advocate. He's not going to do it free for you. It's going to cost you some money. Doesn't matter. That's a process. Depends on how much the amount is. If the amount is not worth going through an advocate, you can either write it off. If the amount is big enough, then you have to go through the legal process. Okay. Then you issue a demand notice. Then you have to keep a copy of the demand notice carefully. You will have to keep carefully the registered. When you go to the post office and do a registered letter acknowledgement due, they give you a receipt, postal receipt. That must be kept safely. And when the letter reaches him, he would have signed it with the date. The acknowledgement would have been signed with the date. That is very, very important for you, because the 15 days, the countdown begins from the date on which he has returned those dates on the acknowledgement slip. So you must get all these together. So original check return memo. Then you have got this copy of the legal notice, demand notice which you are sending to him. Then the original of the postal receipt, the original of the acknowledgement receipt back from the person who has issued the check to you. So these are all original documents which you must return very carefully. In case he pays the amount within 15 days, the problem is solved. In case it does not do that, then your actual work begins. Demand notice is only the preliminary work. The real work starts after he refuses to pay you, or he does not pay you, or does not communicate to you. And if you go for a compromise, then you lose your right to sue him, because the time would have elapsed by then. So people do compromise, telling them, no, I'll give you some amount, I'll give you later, or I'll give you 1 month time, I'll do it. So after that, if he doesn't pay, then it is gone. So be careful when you are going for a compromise, unless you receive the money within those 15 days. That 15 days could be the maximum. So if you don't, then you'll have to go for an initiation of legal proceedings. Then you have to go to the advocate, initiate steps for filing a check bounce case. So how do you file a check bounce case? You'll have to go through an advocate, definitely. He'll prepare a complaint under section 138 of the Negotiable Instrument Act. It has to be gone to the magistrate. It has to be taken to the magistrate. Jurisdiction. What is the jurisdiction? Jurisdiction is where the branch which has told you that they cannot pay you, you are given it to, say for example, your bank is Canara Bank. I told you the example, I told Canara Bank MG Road branch. Then MG Road becomes your jurisdiction. So whichever is the magistrate court that deals with that particular jurisdiction, the local police will be able to tell you, the advocate also will be able to tell you, for this particular area, this is the court we have to approach. It will be a magistrate's court. So you'll have to file a suit in that particular magistrate's court. And you'll have to give them the original of these two, original check return memorandum. Then the advocate will prepare an affidavit for you. So that also has to be signed and given. Then you have to show them the postal receipt, then the acknowledgement, and the magistrate will go through and find out whether the plaint has been filed within the period of limitation, whether you have presented the check within 90 days as per law, and whether you have filed the case within 30 days after that 15 days notice has gone by. Then everything is in order. Then he will issue a warrant or a summon for the person to attend the court on a particular date. If he does not come, then you can go to the court through your advocate and present a case telling that he is not responding to the summons, has received it but is not being present in the court, and therefore we need a non-bailable arrest warrant. This is also possible, issued only at your request. So you will have to make a request to the magistrate in case you want to further tighten the screws on the drawer of the check, if it's playing truant, not attending the court, etc. And then all these documents that gave you will be marked as evidence. And once the case progresses, then you will be called upon to give evidence and inform the court under oath that this is the check that I received, that he owed you this much money and this was part payment or full payment of the dues, legally payable dues to you, and you have got the check in which place, and where you received the check, and which branch you had presented the check, and all these details. You have to, whatever you have written in the plaint, you have to bring it out in the form of evidence. The court might cross-examine you, the other advocate might cross-examine you, and once it is established, then the court will go through a judgment. Depending on the case, he might give either say a fine, or if he is a senior citizen, he might say, okay, then go with the fine. Or he might say, if he's a youngster and he has paid truant, he might tell him, you pay both the fine as well as go sit in jail for 2 years. All this process will start. It is possible that the drawer of the check can go for a anticipatory bail, fearing arrest. Yes, that is also allowed. But the one problem is, when you have filed the check, you don't have to be present every day in the court. Every hearing, you don't have to be present in the court. Your advocate is enough. You will have to go only when they are called for evidence. That is a must. But whereas the drawer of the check, against whom you have made a complaint, he will have to be present in the court on every hearing. And if he is not able to come, then he has to take the permission of the court for his absence. So these are the problems that the drawer of the check will go through. Now what happens if you are the drawer of the check? You'll have to take precautions. You'll have to go for a bail application, either anticipatory bail, or even immediately after the court has taken cognizance of the plaint, then you'll have to approach the same court, same magistrate for a bail. Depending on the situation, they might, they may not. So all these things you will have to go through. The reverse of what you're trying to do to the other man, you will have to face. So the best thing is, don't give a check unless you have the balance in the account, or unless you're sure. In case you're not able to meet the balance, meet the check amount, it's better for you to contact him in advance. Take him into confidence and tell him, please present it on such and such a date. If the date is, the request is within the 90 days. If you're going to cross the 90 days, then you don't have any alternative. You'll have to face the consequences, because he's not going to wait for you. So this in general is what is called the check bounce law and how the procedures are, and how it will either benefit you or affect you depending on which side of the check you are. Whether you have signed the check or you have received the check depends on that. So my friends, this is all about check bounce law and how you'll have to handle the check bounce case, and how you'll have to face in case your check is the check that you have issued as bounced. So with this information, this is the basic information. When the rest of it, your advocate will be able to tell you. But suffice to know the repercussions of what would happen, which in general you may not be able to know. So I'll be happy that this information is useful to you, and you'll be benefited with this bit of information. In case you have any doubt, you can always mail me at dr.vijayakumarkb@gmail.com, or inbox me on Facebook. Thank you. Wish you all the best.